Thank you, Jason, for those kind words, and thank you also for the invitation back to Weston. It's always nice to come to somewhere called London, which is calm and peaceful for a change. You're very lucky here at Weston to have such a great tradition in tort law scholarship, which is being ably carried on by Jason and his colleagues in the present day, and I think it's a sign of that strength that you have this tort law research group. And I have to say, looking at the list of previous speakers in this series, I was a little bit awed by them, and I think it's a real testament to Western strength in tort that such great speakers have enjoyed coming here and the discussions that they've had here. So, the purpose of, the title of my paper today, my lecture, is Damage in the Law of Negligence. But before I get on to that particular subject, I want to begin by situating damage within the broader negligence inquiry. And I think it's worth emphasizing at the outset that negligence is by far the most important tort in the common law world. In terms of its practical significance. So if we look, for example, at England or the UK, we have something called the Compensation Recovery Unit, which has to be informed of every personal injury claim that is brought in the UK. And according to the Compensation Recovery Unit, we get about 1 million personal injury claims in the UK each year. And all of those claims, almost all of those claims, are going to be negligence claims. Now, you can add on to that also property damage claims that don't go through that process, and you can see that this is a lot of claims. We have a population of something like 60 million people in the UK, so that means that on average every UK citizen is going to bring at least one negligence claim in their lifetime. And I assume it's a similar picture here in Canada. I know that systems differ in terms of whether they use fault liability for road traffic accidents, and that makes a huge difference and so on. But even in countries that have systems of strict liability and so on for road accidents, negligence would still be the most important cause of action. And the difficulty seems to me to be that although negligence is really important in practice, the theory of negligence is still very problematic. So this is, it seems to me, a tort which has real issues around its conceptual structure, around the way that negligence law works. This is not set in stone. It's not something that people have agreed about. And there are still real difficulties around how negligence works, how we put it together, the sort of conceptual stability, if you like, of the cause of action. And since I started teaching tort over 20 years ago, that doesn't seem to me to be something that's improved. If anything, I think it's got worse. So I think an important role of tort lawyers, tort scholars, is to try to really work out the conceptual coherence of this tort. How does it work? What is the best way of understanding what's going on? When we get that stabilized and we get that clear, we can move on to interesting questions about the scope of liability in particular contexts and so on. But we do have to get that basic structure right. And so I thought I would actually start the lecture not by talking about damage, but by just giving you a brief overview of the negligence tort. When I was coming into Canada through Toronto Airport, the immigration officer asked me what I was doing here, what's the purpose of my visit or whatever, and I said, well, I'm going to give a lecture on the law of negligence. So very sensibly, he then said, oh, do you work in the insurance industry? I said, no, actually, I teach law. And then he said, oh, well, give me a crash course in negligence, which I thought was an ironic turn of phrase, but also I didn't actually have very long to do this because the next person was waiting in line and so on. So what I'm going to give you now is that crash course in negligence, and then I'll move on to look a little bit more detail at damage. Okay, so as I've indicated, there's by no means agreement on the structure of the negligence tort in the common law world. But my view is that negligence liability can best be understood in terms of 6 general elements in respect of which the plaintiff bears the burden of proof. If the plaintiff establishes the existence of these 6 elements, then the burden of proof shifts to the defendant to establish one of the 4 defences to a negligence claim. And those defences are valenti or consent, exclusion of liability, illegality, and contributory negligence. And as I think it might be useful for me to provide a sort of general overview of negligence by briefly considering each of those 6 elements in turn. And if you've got a copy of the handout that's been circulated, you'll see that I've listed them there. So the first element I'm calling duty in law, and this is part of the 2-part duty of care inquiry. The issue under this heading is whether there is or should be a rule of law that either allows or bars recovery in this category of case. And that's the important point, category of case. So, for example, the question in a duty in law case might be, do the police owe a duty of care to the maker of an emergency call? What makes that a duty in law case is the fact that when the courts answer that question, they have answered it for all cases of that kind. Not just this particular case, but they are answering a more general question about whether the police owe a duty of care to the makers of emergency calls, not just this case. So it's a question of law that operates at the level of categories of case. So that is the first element. The second element then is the element of fault or breach of duty, as it's often known. The issue at this stage of the negligence inquiry is generally whether the defendant created unreasonable risks of injury to others. And we assess this by asking whether the defendant's conduct fell below the objective standard of the reasonable person. Element 3, this is what I'm going to be talking about in this lecture, damage. And at the damage stage, the issue is whether the plaintiff has suffered a form of harm which is actionable in negligence. Then we move on to element 4, factual causation. The issue at this stage is whether there was a historical connection between the defendant's fault and the plaintiff's damage, and that is a question which we generally resolve by asking whether if the defendant had not been negligent, the plaintiff would still have suffered the damage. That's the but-for test. Okay, those 4 elements, not too bad. We then get into deeper water, it seems to me, with elements 5 and 6, which are a little bit more complex. So element 5, I'm causing legal causation, or we might call it the absence of novus actus interveniens. And the issue under this heading is whether there was an intervening act or omission of the plaintiff or a third party which, quote, broke the chain of causation between the defendant's negligent conduct and the plaintiff's damage. So let's suppose, for example, that the plaintiff's injured in a road accident because of the defendant's negligence and taken to hospital. And suppose further that the medical care given to the plaintiff in the hospital is also negligent. This is an unfortunate person. With the result that the plaintiff suffers an avoidable complication of her initial injuries, which leaves her with a disability. Now, in this scenario, the defendant is clearly liable for the plaintiff's initial injuries, but a court might hold that he's not liable beyond that because the negligent medical care broke the chain of causation between his negligence and the plaintiff's disability. They might hold that. It depends on the level of the negligence and the intervening conduct and some various factors. So that's element 5, a little bit complex legal causation. Then finally we get to the final element of remoteness of damage and the connected requirement of duty in fact. The broad issue here under this final question is whether the damage suffered by the plaintiff was the materialisation of one of the risks which made the defendant's conduct negligent in the first place. Was the damage suffered by the plaintiff the materialisation of one of the risks that made the defendant's conduct negligent in the first place? So the example I like to give here is, let's imagine that the defendant is negligently speeding down a country road during a storm when a tree falls on the car, injuring his passenger, the plaintiff. In this scenario, all the other elements that we've considered are satisfied. There's clearly a duty of care. Fault is clear because he's driving too fast. The passenger has suffered damage, personal injury. And this is the bit that people aren't so happy with, but it's true, factual causation is satisfied. Because if the defendant had been driving at a safe speed, if the defendant had not been driving negligently, then the car would have been further back on the road when the tree fell and the passenger wouldn't have been injured. And also in this case, it seems to me that there is no act of the plaintiff or a third party which could be said to have broken the chain of causation. So there's no novus actus interveniens. And yet it's clear that in this case the defendant would not be liable for the reason that the risk of trees falling onto your car is not one of the risks which makes it negligent to drive too fast. And therefore, the remoteness of damage element of the cause of action is not satisfied. Every other element is present, but remoteness is absent because the risk that materialised here was not one of the risks that made the defendant's conduct negligent in the first place. So when we're looking at this question of remoteness, we have to go back to the fault. We have to identify with some precision what the fault was and ask, why was it faulty conduct? It's faulty conduct because you've created unreasonable risks of injury to others. When we get to the remoteness stage, we sometimes have to look a little bit more closely at what precisely those risks were in order to determine whether the damage fell within those risks. Now, there's a requirement which is closely related to the remoteness issue, which is usually referred to as the duty in fact requirement. And this requirement is that the risk of injury to the plaintiff, emphasise those words, to the plaintiff, must have been one of the risks which made the defendant's conduct negligent. And a good example of the operation of the duty in fact requirement is the famous American case of Palsgraf and Long Island Railroad. And if you're interested in Palsgraf, the American law students are obsessed with it, and last time I checked, there was a reconstruction of the facts of Palsgraf in Lego on YouTube. It's not actually accurate. In fact, it's some way from being accurate, but it might help to embed the facts of the case in your mind. So the pleaded facts of Palsgraf were that two train guards who were helping a passenger get onto a moving train, and in the course of this, they carelessly knocked an innocent-looking parcel out of his hands. So he's basically trying to get on this train. It was leaving the station. They were helping him, and in the course of this, they knocked this parcel out of his hands. Unknown to the train guards, the parcel contained fireworks. This parcel then fell under the train. This then caused an explosion, which in turn led to a set of scales at the other end of the platform falling onto the plaintiff and injuring her. Everyday incident. It gets to the Supreme Court of New York, very strong Supreme Court, with Chief Justice Cardozo giving a very famous opinion. And in the Supreme Court of New York, the plaintiff's action against the employer of the train guards fails. And it fails on the grounds that injury to the plaintiff, injury to somebody in her position, had not been a foreseeable consequence of the guard's negligence, and therefore the risk of such injury was not one of the risks that made their conduct careless in the first place. So she fell at the duty in fact stage. Her claim fell at that stage, which, as I say, is closely related to, in my opinion at least, the remoteness stage. Now, if, as in a case like Palsgraf, the duty in fact requirement isn't satisfied, if the plaintiff is not, as it's sometimes said, a foreseeable plaintiff, then the courts will hold that the defendant did not owe the plaintiff a duty of care, despite the fact that the plaintiff has cleared the duty in law hurdle and established that in this type of case, liability can be imposed for negligence. So, as I say, the duty of care inquiry is really a composite of two questions, the question of duty in law and this question of duty in fact. Now, it's worth emphasising at this point that the duty question, the duty in law question, is rarely an issue in straightforward cases where a positive act of the defendant has caused the plaintiff physical injury or property damage. So in everyday negligence disputes involving, for example, at least in England, accidents on the roads and at work, that's our bread and butter in terms of negligence, duty in law is usually not something that the court needs to worry about at all. Duty in law becomes an issue only in what we might call non-paradigm cases. So cases of pure economic loss, psychiatric injury, omissions cases, third-party cases. Non-typical cases, sometimes a duty in law question becomes enlivened. And it's also worth saying, I think, that elements 5 and 6 of the negligence inquiry, so legal causation and remoteness, are also rarely an issue in practice because they tend to arise as problems in atypical or unusual fact scenarios, like the freak accident in Palsgraf. Again, you don't really come across them very routinely in personal injury litigation. So when we set aside these three more peripheral elements, we're left with the three elements that I would regard as being the conceptual core of the negligence tort, namely fault, damage, and factual causation. And there's something quite simple and straightforward about these three elements, if you think about it. Fault is the element that identifies the defendant as the person who could be liable here. They did something wrong, they acted negligently. That's why they may be liable. Damage is the element which identifies the plaintiff as somebody who may have a claim. It's the fact that the plaintiff has suffered damage that means they may have a claim. And factual causation is the element that links the two. It links the plaintiff and the defendant. It links the damage and the fault and the damage. So if we get rid of the more peripheral stuff, the conceptual core of negligence is actually quite simple. And that is really what I want to kind of focus on today. Now, of those three fundamental building blocks, the one that's attracted the most attention in recent years, I think it's true in Canada, it's certainly true in the UK, is factual causation. So about 15 years now, the appellate courts and academic writing across the Commonwealth, and as I say, particularly in the UK, has been very much focused on factual causation for various reasons. Fault, well, this is the issue that most often determines the liability question in practice. So if you talk to a practitioner about negligence, liability questions, fault will be the thing that comes up most often. And inevitably, it's been the subject of close academic attention over the years. I think it's fair to say that it's less fashionable as a topic now than it was in the past. By way of contrast, the damage element of negligence has generally been underemphasized by common lawyers. And let me give you three illustrations of this neglect. The first illustration, or the first point, if you like, is that issues about damage are frequently repackaged as questions of duty or causation. So the courts don't acknowledge it as an issue in its own right. They regard it as a question of duty or sometimes causation. And for a recent example of this, you can look at this Singaporean Court of Appeal case called ACB and Thompson Medical, very recent decision, very sophisticated judgment, very interesting judgment, but the Court of Appeal in Singapore explicitly choose to categorise the issue of damage as a duty question. And that's just an example of what goes on. Second reason or illustration of this neglect, important extensions of the categories of damage take place with little or no analysis or even acknowledgement of the fact. So you'll come across cases sometimes where the courts have actually extended the boundaries of damage, but they haven't even acknowledged that they're doing that. And the third symptom, if you like, of this neglect is the treatment given to the damage issue in tort textbooks across the Commonwealth is generally cursory and frequently non-existent. And I'm afraid I think that's probably just as true in Canada as it is elsewhere. So it's a kind of Cinderella element of the inquiry, essentially. And we might ask ourselves why that is. Why is it so neglected, this damage concept? One interesting clue, it seems to me, lies in David Ibbetson's observation in his historical work on obligations, that it was only in the latter part of the 20th century that lawyers began to focus on the type of harm that had been suffered in negligence cases. Previously, lawyers had been more concerned with the way in which that harm came about. And since those same predecessors had written the textbooks that established the analytical structure of negligence, it's perhaps not surprising that until recently there was very little academic interest in the damage concept. I think another reason for this neglect is that the question of what counts as damage has tended to arise indirectly in negligence cases rather than as an issue in its own right, although I also think that that's starting to change. So, for example, because the requirement of damage completes the cause of action in negligence, it's the last piece of the jigsaw, it's that chronologically speaking, it's the last element, that means that the limitation period starts to run only when damage has been sustained. And so many of the older cases on damage are actually limitation cases, where it was clear that the plaintiff had suffered damage, but the outcome of the limitation issue depended on precisely when the damage was deemed to have occurred. You still see that today. Quite often this damage question is there, but it's there in this kind of indirect way. So my primary purpose today is to try and shine a little light on this dark corner of our law of negligence and to demonstrate that when we turn our gaze onto the damage element, a multitude of important and often difficult questions are revealed. But precisely because there are so many questions raised by this requirement, I have to narrow my focus a little bit and pick out just a few of those questions for closer inspection. So what I'm proposing to do is to begin by making some general observations about the damage concept before going on to look in a little bit more detail at the two paradigm forms of damage, namely personal injury and property damage. Okay, so to structure my discussion of damage in general, I want to make and then defend three propositions, three separate claims about the damage concept. And those claims are as follows, and this is all on a handout. First of all, that a clear distinction must be drawn between damage and damages. Secondly, that it's impossible to devise a good general definition of damage. And thirdly, that damage is a normative concept. So let's look at those in turn. First claim, a clear distinction must be drawn between damage and damages. So unlike in many civilian systems, in the common law world, we draw an important distinction between the damage which is sufficient to establish a cause of action in negligence, which is what I'm basically talking about today, and the harms for which recovery is permitted once the cause of action has been established. So to give you an example, in an English case from the 1990s called Riley and Merseyside Regional Health Authority, the plaintiffs were an elderly couple who were stuck in a hospital elevator for an hour as a result of the negligence of the hospital authorities, and this experience caused them to suffer anxiety and distress. It was a pretty crowded elevator, so it was a pretty unpleasant experience. Their claim in negligence was rejected on the grounds that mere emotional distress without lasting psychological consequences was not actionable in negligence. In other words, they had not suffered damage. But if the same kind of emotional distress had been brought about by an injury that was independently actionable, such as a broken leg, then they would probably have been able to recover compensation for it as part of their action, as part of their claim in respect of that injury. So freestanding, it's not actionable, but if you've got an actionable injury, you can tag it on to that as part of your claim. So that's my first general point. My second general claim is that it's impossible to define damage for the purposes of a negligence action without falling into circularity. So basically, it's impossible to devise a good general definition of damage. So an example of a circular definition would be, quote, an interference with an interest protected by the law of negligence. Why is that circular? Well, it's because the question at the damage stage is this an interference with an interest protected by the law of negligence? So how are we defining damage? Well, okay, you get the idea. We're not going anywhere here. Now, the reason why this is the case, the reason I think it is impossible to devise a good general definition of damage is that although the core of the concept is easily identifiable as physical damage to the plaintiff's personal property, even this core notion of physical damage is quite hard to define with any degree of precision, as we're going to see. And when we extend damage beyond physical injury to encompass harms like psychiatric injury, possibly things like loss of freedom of movement, that makes the task of definition even harder. So it seems to me the result is that attempts to define damage in general terms inevitably fail. And a good example, it seems to me, is Lord Hoffman's definition of damage in the House of Lords in Rothwell and Chemical Insulating Company as, quote, an abstract concept of being worse off physically or economically. Now, that's on the handout. Now, one difficulty with that definition, one difficulty is the limitation of the concept of physical and economic harms, because you can recover in negligence for mental injury in some circumstances. But even if we amend the definition and stop at the comma, so we just say an abstract concept of being worse off, there are still two big problems with this definition. The first problem is that not all forms of being worse off count as damage, as is shown by the fact that a plaintiff who loses a loved one as a result of the defendant's negligence, and therefore is obviously worse off, is not deemed to have suffered damage for these purposes. And the other difficulty with Lord Hoffman's definition is that in some cases the plaintiff may be better off as a result of the defendant's negligence but will still be considered to have suffered damage. Now that second difficulty is best illustrated by Ernest Weinrib's fabulous example of the accident on the way to the airport. So suppose that I am run over and injured by the defendant while on my way to the airport, and suppose that as a result I miss my plane, which then crashes on takeoff, killing all those on board. Only a tort lawyer would come up with an example like this, but anyway. Now in this case I'm clearly better off as a result of the defendant's negligence. In fact, the defendant's negligence has saved my life. And yet the physical injury I suffer still amounts to damage for the purposes of a negligence claim. I can still bring a claim for whatever it is, the broken leg. So in my respectful opinion, therefore, Lord Hoffman's definition of damage fails. And indeed it seems to me that what Lord Hoffman was really defining in the Rothwell case was loss, a concept which I think can properly be understood in terms of being made worse off, and which I argue in a recent article entitled Rights, Damage and Loss is a fundamentally different concept from damage. So one of the arguments in that article is that damage and loss are fundamentally different things. And I think Hoffman was defining loss rather than damage. It's a good definition of loss, by the way. Okay, so it follows in the second claim that rather than trying to define damage in general terms, I think it's more useful to look in detail at the various different kinds of harm which are and are not actionable in negligence, personal injury, property damage and so forth, and that is what I'm going to do in the final part of the lecture. Before I do that though, I should just address the third claim, the most esoteric in a way, which is the claim that damage is a normative concept. So what I mean by this third claim is that damage as an element of the cause of action for negligence is a legal construct rather than a purely factual phenomenon. So to illustrate this, let's imagine that in the course of this lecture I get so excited about the intricacies of negligence law that I start gesticulating wildly, and in the course of doing this I smash this very attractive lectern. Now, we might look at this smashed lectern and say that in ordinary language it suffered damage. But if Western University wants to bring a negligence claim against me, which would be ironic, then it won't be enough for it just to point at the lectern and say that lectern is damaged, because it will also have to establish that it had either legal ownership of or possessory title to the lectern at the time I smashed it. And unless it can do that, the university won't be considered to have suffered damage that would ground a negligence claim. So this is my point. There's a distinction between the physical fact of the lectern being damaged and the normative fact, if you like, of the university having suffered an invasion of a legally protected interest. And that's what I'm trying to bring out in this third claim. Now, one of the reasons I think we lose sight of this point about damage, and in fact I think one indicator that we do lose sight of it, is the fact that judges and commentators often don't just talk about damage, they talk about actionable damage, which I think is tautologous, because the whole point of the damage requirement is whether it's actionable or not. So why do we lose sight of this point? I think it's because most negligence claims are for personal injury, and in those cases this distinction between damage as a factual concept, the smashed lectern, and damage as a normative concept, the invasion of a legally protected interest, generally doesn't matter, because by smashing my leg, you by definition invade my legally protected interest in bodily integrity. So we don't get this complication that we get in property damage cases. However, even in personal injury cases, this distinction can sometimes become important, as is shown by the fact that in English law at any rate, an unwanted pregnancy can amount to a personal injury for the purposes of a negligence action, whereas a desired pregnancy can't. And in this scenario, therefore, although the physical reality of the pregnancy is exactly the same in both cases, the plaintiff's perceptions about it can turn something that would not otherwise amount to damage into something that is. So it's a normative concept, and when we're looking at questions about, for example, what interest do you have to have in property in order to bring a negligence claim in respect to property damage, that seems to me to be a damage question. I struggled for ages with locating that in my reading list, but eventually I decided it was, in my view at least, a damage question. Okay, I want to finish by taking a closer look at the two most typical forms of damage, namely personal injury and property damage. I may have to skip over one or two things just for reasons of time. It might be all right, we'll see. But I want to start with personal injury. So personal injury cases dominate the modern law of negligence. As I was saying earlier, in the UK, probably 1 million plus cases a year of personal injury claims. But what exactly do we mean by personal injury? Well, a useful starting point, in my opinion, is the non-exclusive definition of personal injury that can be found in Section 38(1) of the UK's Limitation Act 1980, which says that personal injury, quote, includes any disease and any impairment of a person's physical or mental condition. Now, one of the reasons I like that definition is that I argued in an article I wrote in 2013 about damage that impairment is the central idea which underpins both the concept of personal injury and the concept of property damage. And by impairment, I think we mean making something worse, weakening it, reducing its utility or effectiveness. So, for example, a broken leg is impaired because it's more difficult to stand on it, walk on it, and so forth. I also suggested in that article that a broad approach is and ought to be taken to this question of impairment. So a condition such as back pain that causes the sufferer to feel discomfort amounts to a personal injury, for example, as does a disfigurement, even if neither of them in any way affect the mechanical functioning of the body. So it's a broad approach to this governing notion of impairment. And I think that's the approach that the law takes. Now, it's interesting that the draftsman of the Act includes disease as a separate element within this definition. And I guess what that suggests is that the draftsman was concerned that not every disease would be deemed to amount to an impairment. And I can see why the draftsman might have thought that, although I think you can also argue it the other way. But let's take Jane Stapleton's example from her seminal 1988 article on damage of a plaintiff who can prove by imaging evidence that he has contracted mesothelioma, a form of cancer, as a result of the defendant's fault, even though this has not yet resulted in overt disabling symptoms such as shortness of breath. Now, even though it could be argued that this disease does not yet amount to an impairment, it seems to me Professor Stapleton was clearly right to maintain that the plaintiff has suffered damage such as would ground a negligence action. And this is reflected, I think, in the pneumoconiosis example that Lord Pearce gives in Cartledge and Jopling. So we might regard the inclusion of disease as a separate element as a sort of avoidance of doubt point, taking into account the kind of example that Jane Stapleton has given. At the same time, we've got to be careful not to give the term disease an overly broad ambit, as is shown by the decision of the House of Lords in Rothwell and Chemical and Insulating Company. So the plaintiffs in Rothwell have been negligently exposed to asbestos by an employer, as a result of which they have developed pleural plaques. And these are a thickening of the lung lining, which indicates that there has been asbestos exposure that may later manifest itself in asbestos-related injury. So they're a kind of marker of asbestos exposure, pleural plaques. House of Lords in Rothwell held that since these plaques were almost always symptomless, had no effect on bodily function or appearance, and did not increase the plaintiff's susceptibility to disease or shorten the plaintiff's life expectancy, they would not in themselves generally amount to personal injury. And according to Lord Hoffman, he said symptomless bodily changes with no foreseeable consequences could not constitute damage for the purposes of a negligence claim. Now, if we ask ourselves what the difference is between the pleural plaques in Rothwell and Professor Stapleton's example of the symptomless cancer, it seems to me that the answer is the likelihood that without treatment, the cancer will develop into a disabling, potentially fatal condition, which among other things may mean that immediate and invasive treatment is required. By contrast, pleural plaques are not the early stages of an asbestos-related disease, but merely an indicator that the plaintiff may develop such a disease in the future. So I think there is a difference between the pleural plaques and Professor Stapleton's example. So it follows that, in my opinion, Rothwell was correctly decided, even if in fact it proved very controversial politically. I think it's much more controversial politically than amongst legal academics. And indeed it was subsequently reversed by legislation in Scotland. Not a very well worded piece of legislation, we won't dwell on that. But the Scottish legislature, under political pressure from trade unions and so on, didn't like this decision at all. But I think as a matter of principle, as a matter of negligence law, the House of Lords made the right call. But there's another case coming up through the English courts at the moment, which I think is more difficult. And this is a case called Greenway and Johnson-Matthey. And I think it's a case that's right on that borderline as to whether something's a personal injury or not. So the facts are somewhat complex, but I'm going to give them a go because I think it is an interesting case. Plaintiffs in this case were employed in the defendant's factories, making catalytic converters. Defendants didn't clean their factories properly, and as a result, the plaintiffs were exposed to platinum salts to a greater extent than they should have been, and this amounted to a breach of duty on the part of the defendant. Exposure to platinum salts can cause two conditions. The first is platinum sensitization, which is an asymptomatic condition that doesn't cause any health problems in the absence of further exposure to platinum salts. And the second condition is platinum allergy, which is caused by the continuing exposure to platinum salts of an already sensitized individual. So it's kind of a two-stage thing. First you develop a sensitization, and then if you don't stop the exposure, you can develop an allergy. Now, unlike platinum sensitization, platinum allergy does have debilitating symptoms, such as a runny nose and eyes, skin irritation, bronchial problems, and the defendant in Greenway accepted that the development of platinum allergy would amount to a personal injury. Now, it's worth also mentioning at this point that platinum salts are not something that you're going to come across in the supermarket. They're not something you're going to encounter in everyday life. They are only used in a few very specialised work environments, and that's important, I think. So the plaintiffs in Greenway had developed platinum sensitization, not allergy. This had been picked up because they were doing routine tests of their workers to see whether this had happened. And the result of that was that the defendant either redeployed them to less well-paid jobs where they wouldn't be exposed to platinum salts, or if this wasn't possible, dismissed them from their employment and provided a payment under the terms of collective agreements with the plaintiff's trade union. Plaintiffs then sued the defendants in negligence or in tort. There's also a breach of statutory duty argument, arguing that as a result of the defendant's wrongful conduct, they had suffered personal injury on the basis that their bodies had undergone a physical change by acquiring platinum sensitization, and that this had had an adverse effect on them financially speaking. So this was a personal injury, they argued. This argument was rejected by both the trial judge and the Court of Appeal, and I've put a statement which kind of sums up why the Court of Appeal rejected this argument on the handouts from the leading judgment of Lord Justice Sales. So he says, on the medical evidence, platinum sensitization is not harmful in itself in any relevant sense. It's a physiological change analogous to the development of pleural plaques in the lungs in the Rothwell case, and hence does not constitute actionable damage or injury. Unlike the lung scarring from pneumoconiosis in cartilage, platinum sensitization is not a hidden impairment which has the potential by itself to give rise to detrimental physical effects in the course of ordinary life. The removal of the appellants from their jobs is detrimental for them in financial terms, but as the judge observed, this was a form of pure economic loss. The presence of such economic loss does not convert a physiological change, which does not in itself qualify as an actionable injury, into such an injury. Now, I think Greenway is a difficult case. I can see that there are strong arguments on both sides, and indeed the case is going up again. It's been appealed again, and it's going to be heard by the UK Supreme Court later this month. So if you're really interested in this topic after my lecture, which is unlikely, but you never know, you can watch live streams of the argument to the Supreme Court on the 27th and 28th of November. All right, what do I want to say about Greenway? Well, basically just want to make three observations about this case. The first is that in his judgment at first instance, Justice Jay said that, and I quote, "One cannot define the actionable injury by the steps which are taken to prevent it. One cannot define the actual injury by the steps which are taken to prevent it. That seems to me to go too far. I mean, this is one of his reasons for dismissing the claim, but because it would logically follow that a person who developed a debilitating photosensitivity as a result of the defendant's negligence, which meant, for example, that they had to take very onerous precautions when going outside on a sunny day, would not be considered to have suffered a personal injury, and I think they have. By contrast, Lord Justice Sales in the Court of Appeal implied that this would amount to a personal injury, the photosensitivity example, because it would have, quote, detrimental physical effects in the course of ordinary life. And I regard that as a sort of welcome clarification. So that's my first point. Second point, I think this is probably the point that convinced me that the Court of Appeal were right in this case. There's a very strong argument in favour of the Court of Appeal's analysis, is this, that it's hard to see how the plaintiffs in cases like this, cases like Greenway, could be awarded any general damages as opposed to special damages for their economic loss. So if we take the example of a retired employee who's become sensitised but who has never suffered and will never suffer any loss of earnings, no general damages mean no damages at all, and that would be very strange in a negligence case. So you don't win a negligence case and come away with no damages, it seems to me, and that's perhaps the point that convinced me that the Court of Appeal were right in Greenway. Whereas if this sensitivity that they developed was something that affected them in their everyday lives, you would then get general damages and there would be no problem. And the third point, which I suppose follows from that point, is that the approach that Lord Justice Sales takes to this issue serves as a useful reminder that from a legal perspective, the concept of personal injury is essentially a functional one which focuses on the practical significance of the defendant's conduct on the plaintiff's everyday life, and I think that's really helpful. Okay, I think I can just talk a little bit about mental harm before I move on to say some words about property damage. So one of the issues, and one of the questions I'd like to address under the heading of personal injury is the question of mental harm as a damage question. So in English law, a plaintiff who alleges that the defendant's negligence has caused her mental injury alone, not consequential, but mental injury alone, must establish that she's suffering from a recognised psychiatric illness in order to recover damages. Normal human emotions such as grief, sorrow and anxiety give rise to no redress. So, for example, in the Rothwell case, the House of Lords held that no action lay for anxiety brought on by the knowledge that the plaintiffs had been negligently exposed to asbestos and so were at heightened risk of contracting an asbestos-related disease in the future. The anxiety on its own, unless it amounted to an illness, was not compensatable, was not damage. Now, this requirement of a recognised psychiatric illness is not applicable, it seems, in Canada, as confirmed by the Supreme Court of Canada in its recent decision in Sardati and Moorhead, where the plaintiff recovered for psychological injuries, including personality change and cognitive difficulties, even though it hadn't been demonstrated by expert evidence that he was suffering from a medically recognised psychiatric illness. Now, I'm running a little bit short of time, so I put a quotation from a key passage in the judgment of Justice Brown on the handout, but I'll leave you to read that afterwards, if I may, because I need to keep moving. As Justice Brown points out in the judgment, this was a case about whether the plaintiff had sustained damage. And clearly opinions can differ as to whether mental harm that falls short of a recognised psychiatric illness should indeed be capable of grounding a negligence claim. That's just a question on which we can disagree. But what I was not persuaded by with respect was Justice Brown's characterisation of this limitation in that passage on the handout as an arbitrary mechanism designed to control liability for mental harm, because instead I would regard it as simply the playing out of the damage issue in this context. So you may not like the way the issue is playing out. It doesn't seem to me that you can characterise it as an arbitrary mechanism. And nor am I persuaded by Justice Brown's suggestion that this restriction is, quote, premised upon dubious perceptions of psychiatry and of mental illness, when the limitation that applies in England and in other common law countries actually defers to the psychiatric profession's definition of mental illness to determine the damage question. Do I think this requirement is justified? Well, on balance, I would say probably yes. One difficulty, if you get rid of it, is that the courts will inevitably face problems in determining whether a lower threshold has been reached. So you don't want recovery for ordinary emotions. If you don't then require a recognised psychiatric illness, it's quite hard to set a threshold that's really workable in between. And another point I would just make is that this restriction is not only found in most common law countries, but it's also found in most civilian systems. So in German law, for example, you can only recover for mental harm if it amounts to mental illness, and both sets of pan-European principles of tort law also incorporate an equivalent requirement. And the handout gives you an example. It's a lot of legal systems do require this. Canada, also the US in its own way, although the US has very tight restrictions at the duty of care stage, so it's a slightly different picture. But in North America, at least, this requirement has gone, or is not recognised. Okay, I wanted to just say a few words about property damage. Running out of time, but it would be useful, I think, to say something about property damage. I've put a definition of property damage on the handout from a case called Hunter and Canary Wharf, a case you may come across in the law of nuisance. But there was also actually a negligence claim at the Court of Appeal level. And in the English Court of Appeal, Lord Justice Pill defined property damage as, quote, a physical change which renders the article less useful or less valuable. This definition makes it clear that there are two distinct elements to the concept of property damage. This is really the point I want to emphasize. You've got two different elements that you need to establish: a physical change and a diminution or impairment of the usefulness or value of the thing in question. If either of those two elements are missing, you don't have property damage. So, for example, I don't damage your property by bringing about a physical change, for example, by heating it or cooling it, unless that change also impairs its utility or its value. And conversely, it also follows that by impairing the utility or value of your property without physically changing it, I don't damage it either. And there's a good example of that second point from a case called Pear and a Pand in Australia. But just to give you a more straightforward example, it's not enough for the defendant simply to incapacitate the plaintiff's property. For example, by attaching a clamp to the wheel of the plaintiff's car to prevent it from being moved, or blocking the access to the plaintiff's garage with the same result. The wheel and the clamp, the car and the garage, are in exactly the same physical condition. And so these interferences do not amount to damage for the purposes of a negligence action, although they may ground claims in other torts concerned with the protection of personal property interests, things like conversion and trespass to goods, but not negligence because not damage. Okay, to scratch the surface of something could certainly amount to property damage, subject to principles of de minimis, of course, but in any case, that's really all I've done in the overview that I've given you today of the damage element of the negligence inquiry. To see the full picture, you'd have to consider a host of other questions, such as whether imprisonment is a form of damage that grounds a negligence claim, whether an untreated learning disorder such as dyslexia is a form of personal injury. The English courts have said that it is. Whether loss of reproductive autonomy, in other words, the ability to control the size of your family, counts as damage in negligence. Whether the permanent loss of property, not damage but loss of property, is a form of damage. And perhaps most controversially of all, whether there is damage in so-called wrongful life cases, where a severely disabled child argues that she would have been better off if she had never been born. And I should also mention before I finish one other very difficult question, which is whether merely being exposed to the risk of physical harm should be recognised as a form of damage that can be the basis of a negligence claim. So you will come across, will have come across when you study negligence, the whole question of loss of a chance. This is a question, it's a difficult question. but it seems to me that understanding that issue is concerned with the damage element is an essential first step towards understanding the nature of the problem. So a large part of our task as students, scholars and practitioners of the law is to come up with the answers to difficult questions. But we shouldn't forget that one of the most important things we need to do is to identify what question we should be asking in the first place. And I hope that today I've managed to convince you that, as Justice Hayne recognised in the Australian wrongful life case of Harrington and Stevens, in negligence law, whether the harm suffered by the plaintiff does or ought to count as damage is sometimes the right question to be asking. Thank you.